Hi, here is the resolution of the hypothetical on trademarks and domain names corresponding to the class that was cancelled last December. So the case is about Moana. I hope that you have read the hypothetical, and then you will see that in fact it's based in real facts, but as all good movies, novels, and series, it's based on real facts with some tweaks. There is indeed a film called Moana by Disney that in continental Europe was called Vaiana for a couple of reasons. One was due to the real fact that Moana was a registered trademark for perfumes in Spain and other countries, contrary to the hypothetical, and the uses of this trademark was not as marginal as I have presented here. The second reason is because Moana in Italy and France, but especially in Italy, is something else. It's basically the name of a very famous porn actress that was not exactly the kind of target public that Disney was intended. So, having said that, let's go to the facts as presented here. And first of all, we have the question of the title. What do you would advise real films, in this concrete case, to do regarding the name Moana? So the first thing to take into account is that you don't need a trademark for a movie picture, for a film, because in fact the name is protected by copyright. The other question indeed is that it would be very useful for anything regarding merchandising. Here is when you want to start producing, backpacks and necklaces and perfumes, etc., and anything, products sold in relationship with that film, then copyright will not provide you an adequate protection. You will need a trademark for putting all those products and services in the marketplace. So this is why you would need the trademark Moana in this case, not for the movie itself, but indeed in this case it was needed according to the facts as presented in the hypothetical. So, could you register a trademark Moana? The problem is that we have a prior registration for perfumes, which is class 3 in the Spanish and international trademark classification, the NIST classification. Let's forget that. We'll see that in the next slide. The following answer is that yes, you could register that for any other product except most likely perfumes, as we'll see. And this is what happens in registrations. Please check Article 7 of the directive that will explain to that exactly that is not rejected because it's not allowed in one kind of products, is accepted for all other products where there is no conflict. For perfumes, which is one of the products that you're interested in, or your client is interested in, you have many different strategies. We'll check the hard ones in the next slide, but one of them is just trying to bypass that by registering other trademarks with other variations of Moana, all the Moana waves, whatever you want to imagine, or a graphical trademark, just the logo, as presented in the previous slide, as a trademark for only perfumes, hoping that this will not create a problem for the reasons we will see in the next slide. So, here we have the question of what's the real problem with the Moana trademark for perfumes in Spain, a trademark that's very old, that's still valid, but that has not been really used as that for a certain time. So the first question we need to see is, whether there is an impediment here. Indeed it is. If it is the same sign, Moana and Moana, they are in principle the same products, perfumes and perfumes in the same class, class 3. So the result is it could not be registered according to Article 5.1a, that standard. Now, the first thing we will need to do, you will need to advise real films to do, is try to show that in fact 5.1a is not applicable because these are not the same products, even if it's clearly the same sign, but there are similar products, and therefore we can also need to examine whether there is risk of confusion. And our position will be they are not the same products, they are similar or even not that similar. And in any case, there is no risk of confusion. Why? Well, we could elaborate on the fact that the targets are very different. They are addressed to different target publics. In one side, you will have normal people, in that case, women that want to buy perfumes as such. On the other hand, you have pre-teenage and teenage girls that just want merchandising about the Moana film itself, not that much the perfume. That this will be in fact more considered as an additional product, a reference to fandom than a real perfume, that it would be sold through different channels, not in perfume shops, but in Disney shops or real film shops in this case, etc., etc. I don't know how far this could go, but at least you should try to prove, that's the first thing to do, that the products are not the same, they are in different markets, and you try to segment the market as you can. There is one thing that clearly has some room here for convincing, is the fact that these products are sold basically as collectibles. And we could clearly claim that collectibles and perfumes are different things, once again, with different customers, different markets, different rules, different distribution channels, different market rules, etc., etc. Now, most likely, as the sign is exactly the same and the product is exactly the same, the trademark office itself will reject the application, so we should appeal against that. And most likely, the owners of Moana trademark for perfumes will also object to our application. So we should, file allegations on their objection. Okay. Now, whether we will succeed in convincing the trademark office, or the appeals chamber, or the court in appeal regarding whether this is the same product or not, is something to be seen. Certainly, it will take some time, probably more time than we have. The second line is probably the first one you have thought about, which is the fact that most likely the Moana trademark, as in the trademark registry, is not valid anymore for lack of use. It has not been produced any new perfume since the last 35 years or more, and therefore we could argue that this is certainly more than the 5 years in the legislation. Therefore, this trademark is not valid. This has different roles in different articles. Please check articles 16.1, 19.1, 44, 1 and 2, and you will see that there are different rules here. That is, this is an argument for objecting to their objection, okay, but there's also an argument for directly filing for the invalidation of their trademark. This is really the cancellation. On one side, we're saying, well, your trademark has a pathology, you don't have the right to object to our use. On the other side, we're going directly to ask for this trademark being cancelled from the registry, and therefore, at that moment, we would not have any obstacle anymore. Once again, whether we succeed or not is a question of time. It would take something between 6, 8, 10 months, 24 months, probably, the whole procedure, for both things, the appeals and the validation, etc. And it depends. I mean, perhaps Abril Films has scheduled this in a way that has time to launch the film after that, because this, the preparation of all the merchandising and the launch of the film comes years prior to the actual release, or perhaps not. And you don't have that much time. If you don't have that much time, you will need other strategies, which would start indeed with trying to conclude, to strike a deal for licensing. That is going to these people that are using a marginal. You say, look, we pay you some money or some significant money to use the trademark for perfumes, and that's it. Indeed, in order to convince them to negotiate the licensing, you need to do all the prior actions. That is, you need to file for the trademark for all the other products, file for bypassing trademarks, that is graphic trademarks and similar trademarks for perfumes. You need to challenge their trademark for lack of use. You need to claim that your trademark is a different product and therefore is not confusingly similar in a different market. But at the end you will see whether there's a possibility of licensing or not. And whether this works or not is a question that's outside the scope of the hypothetical. It may work or not. So at the end, you may be able to use the trademark Moana or just go back to, Moana, or need to file for a different application, a different one, like in this case we said Vaiana, which was the real one. Okay, so the next thing is regarding the European Union trademark, whether you could register that as an European Union trademark everywhere but Spain. The question again here is, yes, you could register that for everything but perfumes. For class 3, it would be rejected. And for class 3, it would be rejected for all countries, not just for all countries but Spain. There's a unitary aspect of the European Union trademark that prevents the European Union trademark from being registered in some places but not in some others. All or nothing. Contrary to the products, you may have some products, the ones where there's no conflict. But regarding the territories, it's all the territories or not territories. So the alternative here would be to file for registration in national trademark offices one by one, or just applying one and asking via the Madrid Agreement, the so-called international trademark, an extension for all the other countries, once again, except Spain here for perfumes where we have the real conflict. And indeed, everything that we have said in the prior slides regarding the challenges, the possible challenges to the trademark and the possible registration or not for perfumes apply also here.